Thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakrin. I just want to share with you one of the top stories that we are following, and we want to take you beyond the headlines in this case. There was a mistrial declared in the murder trial of a 21-year-old man who's accused of killing a Lithonia teenager. This is, of course, a major story that we've been following here on Atlanta News First. And, it's something that's really been troubling the family of the victim, Tori Lang. So, according to officials, the court declared a mistrial on the most important counts 1 to 5, the most serious charges, which include felony murder. Officials say the defendant here, Austin Ford, was found guilty on the other counts 6 to 8, of theft by taking a firearm, theft by taking involving a vehicle, concealing the death of another. That's Tori Lang. But of course, the big charges include felony murder. The jury apparently was not able to agree on a verdict, and so the mistrial was declared. But you may recall that Lang's body was found in July of 2021 in Yellow River Park in Gwinnett County near Stone Mountain, and she had been shot to death. Her Nissan Versa, which had been set on fire, was found later on, found days later, about 5 miles away in the Hidden Acres Nature Preserve in DeKalb County. And then months after that, authorities announced the arrest of one of Lang's acquaintances, Austin Ford of Lithonia, who was then 20 years old, and he is the defendant in this case, or was the defendant in this case. This 12-person Gwinnett County jury announced on Monday, which was the third day of deliberations, that they were deadlocked, according to officials. Already on Friday, they had indicated they were struggling to reach a decision, saying they were kind of split, especially on those top counts of felony murder, aggravated assault, 2 counts of weapons possession. And Lang's parents, certainly very upset. They've said it's, quote, very intense, been a long time coming, but we're going to try to stay strong. I want to bring in now someone who, follows criminal trials very closely, as a criminal defense attorney herself, Rachel Kaufman, joining us. Rachel, first of all, what is your reaction to the fact that there was a mistrial?
Well, I was hoping that there would not be a conviction because, as a criminal defense attorney, something that's really important that we need to relay to the jury is that the state has to meet their burden, which is proof beyond a reasonable doubt. And what that means is that if there's a reason to doubt that this was a homicide of Miss Lang, which I believe that was really the defense, is that this could have been a suicide, and the medical examiner said as much. Um, that is a reason to doubt that this was a homicide. And so it, the fact that I know there were jurors that really wanted to find him guilty. And I think that's really what must have been the struggle in the jury room. So was I surprised? It's a long way of saying not really, because at least somebody in that room was going to care about the burden of proof.
Um,
Which, if you can't prove somebody guilty beyond a reasonable doubt, it's not whether you like one story versus the other. It's whether there is a reason to believe a different story.
Right. And, the burden of proof, it can't be emphasized enough, is on the prosecutors that, they have to prove their case beyond a reasonable doubt, right? I mean, beyond a reasonable doubt is what, 90+%? I mean, how do you
Well, I
articulate
mean,
that?
when you have the medical examiner saying that it could be a suicide, that she can't say for a fact that this was a homicide, that is a reason. I mean, to me, as a defense attorney, I'm like, how could you convict someone, even if you want to, even if you think that they're guilty? There's a reason that we don't allow convictions. We should not allow convictions based on less than proof beyond a reasonable doubt, because it means taking away someone's liberty. It'll be very interesting to see whether Gwinnett County DA's office decides to go back to trial with this.
Well, very interesting, because, Ford's attorney, the defendant here, says that his client could face between 1 and 30 years behind bars for the charges he was convicted on in the case. And those are, theft by taking for a firearm, vehicle, and also concealing the death of another. So that's substantial, right? I mean, that's potentially up to 30 years in prison, and this is a 21-year-old man. So knowing that, what do you think prosecutors are going to do next? Are they just going to seat another jury, hold another prosecution in this case? What's going to happen?
my guess is that they will prosecute again.
And
Unless
try
they
to
can reach,
convict on murder.
yes, unless they can reach some sort of plea deal, now that they have the leverage of having him convicted, with the risk of facing, up to 30 years. If what's going to happen now is, I would hope that there'd be some discussions between opposing counsel and his attorney to see whether they can come to some sort of agreement such that the family doesn't have to go through this whole process again, and court resources. And again, it should really speak to the truth. I didn't watch the entire trial, but I did watch enough to know that he may have done something wrong, but I don't. But we can't just make the leap and say that that's felony murder. That takes away his entire life,
Yeah.
and I can't say for sure that it wasn't suicide because there's an expert telling me that it could have been.
Well, if this is the case, that we have an expert who is saying basically leaving the door open to the possibility of suicide, then, I mean, why would prosecutors do this all over again and put the family through this all over again? I guess what's the reasoning behind that?
Well, the family does have a say in how things go, not the ultimate say, but I feel like part of their disappointment in all this is the fact that they didn't get the convictions that they wanted. So if the DA's office is going to ask the victim's family what they want to do, it's very possible that they'll say, tee it up again. We want another shot at it.
So certainly, I mean, like you said, the medical examiner's testimony is a critical piece of this case because you have a medical examiner leaving the door open for the possibility that it was a suicide, that it wasn't a homicide. So I guess my question is, how do you overcome that if you're on the prosecution side? I mean, if this does go to trial again and a jury is reseated, what do the prosecutors do? I mean, the medical examiner presumably is not going to change their testimony. So what do the prosecutors do to put forth a better case and try to get a conviction?
I don't want to give them any hints, but then again, I mean, I don't know if this gentleman's in custody. So if he's in custody, I would just be listening to his jail calls. That's all.
Oh,
To
yeah.
see whether he's making admissions or saying things that would lead somebody to believe that it was not a suicide. I'm confused, but I'll say this. I was a little bit surprised that the jury, I think they were trying to, as they say, split the baby, which is at least find him guilty of something to make jurors who wanted to find him guilty of the murder case, feel like they were getting something out of it. And it's the fact that they reached unanimous verdicts on those theft charges. It does put Mr. Ford and his attorney in a situation where now they know that there's that much risk on the table, plus an additional felony murder. I don't know how long he's been in custody. If there's something they could work out where everybody feels like they can move on, they don't get exactly what they want. That's a good negotiation. Either way, it's horrific for the family to have to be in a courtroom with someone who they think killed their daughter. I cannot even imagine.
Yeah, no, it absolutely is. One thing I'm really curious about is we are talking about not, when we're talking about different murder charges, felony murder is different from, the other categories of murder. And, I'm a non-practicing attorney. You're a
I
practicing
was going to say,
attorney.
yes, it is, but it isn't. It
Okay,
isn't here
so
in
you,
Georgia.
yeah, so you tell me because, right? I mean, felony murder, you can be convicted. One could be convicted of felony murder if the death happened in the course of committing a felony. Am I wrong? I mean, even if it wasn't,
So it's supposed to be a forcible felony, but what is a forcible felony? It expands into drug transactions and other things. But more importantly, is that the sentence, mandatory sentence for felony murder, is the same mandatory sentence for malice murder. So jurors sometimes will, and jurors are not supposed to, or they're not allowed to really know the punishment, or consider punishment as it relates to them deciding their verdicts. But the truth is that felony murder is not less. You're not giving them like any sort of consolation prize, or they're not being considered for less time than life if it's a felony murder versus a malice murder, which is like a first degree murder. So, you know, people don't know that, and they think that they're kind of going in between what's a voluntary manslaughter and a malice murder, to find out or not find out, but in the end, the guy gets life anyways.
Yeah, I mean, and that's a fair point, looking at the punishment. But in terms of proving the crime, isn't it easier to meet the elements by law, kind of to meet the legal elements and kind of check off the boxes if you're a prosecutor? Isn't it easier to prove felony murder?
Well, if you shot somebody, or you're accused of shooting somebody, that's, an aggravated assault, and during the course of your aggravated assault, somebody dies, yeah, that's a felony murder. So it takes out the malice.
The intent.
And in this case, like we know, there's really no evidence that he was mad at her, that there had been any sort of conflict or disagreement that would make sense as to why he would kill her.
Yeah, yeah.
So they didn't have that in this case.
All right. Well, it'll be interesting to see what happens next. And of course, this is a case we're going to keep following. Thank you so much to Atlanta-based criminal defense attorney Rachel Kaufman for sharing your insight and analysis with us.
Thank you, Joy.
Thanks, Rachel. All right.
Love ya. Are we on the news?
Oh, appreciate you being with us. Yeah, and of course, we want to let our viewers know that we're going to keep following the latest in the Tori Lang case, including watching to see whether there is a new trial. Thanks for joining us here on Atlanta News First and Atlanta News First Plus.